Under Australian law, it's an offence to bribe a foreign public official, even if a bribe is regarded to be necessary or part of the normal course of business in a particular foreign country. Over the last 3 years, we've seen an increase in investigations into alleged bribery of foreign officials by employees of Australian companies. Last year's prosecution of executives from RBA subsidiaries Securency International and Noteprinting Australia highlighted the need for companies to understand the consequences of getting it wrong. Australian companies may be liable for the actions of their employees and agents under Australia's anti-foreign bribery laws. Prosecutions under Australian law take into consideration whether the bribery of foreign public officials was encouraged or tolerated by management. The court will also seek to determine if there was a failure to create and maintain corporate policies that required compliance with anti-foreign bribery laws and a corporate culture that supported these policies. When it comes to bribery and corruption, Australian companies have more to worry about than Australian law. Prosecutions of Australian executives and employees can happen under both US and UK law, even if the offence was committed in another country altogether. Australians should be aware that under the FCPA, the US can prosecute Australian citizens or companies if the company has a US presence, issues stock in the US, employs US citizens, or engages in business in the US. The crime itself does not have to be committed in the US for charges to be brought. It's more important than ever, therefore, that Australian companies implement a compliance program that has measurable metrics and can be audited on a regular basis to assess its efficacy. Does your company have policies and procedures in place to guard against a potential violation? Have your employees been trained on the difference between a bribe and a facilitation payment? Do you screen your foreign agents before signing contracts with them? Employees working in countries where bribery is common and expected should have training that is custom-tailored to the countries they're working in. They should be made aware of the personal and professional consequences of bribing a foreign official and should have resources available to them should they need legal advice while overseas or require guidance on corporate policy in a given situation. If your company does not have a management-supported and auditable compliance program in place, now is the time to take action. We offer in-house workshops and e-learning courses on anti-bribery and corruption, as well as sanctions, which provide your employees with the key information that they need to understand your company's obligations under the law. We can work with your staff to develop and implement an anti-bribery compliance program that will help you avoid being exposed to bribery and corruption risks both in Australia and overseas. The courses we offer were designed by Financial Crimes Consulting, Australia's thought leader in anti-bribery and money laundering legislation. Contact us today for more information.